afternoon once more. Well, we've come to the end of 2 riveting days, if I may say so, at this stage. And we are so very pleased that we have been here to experience what you have delivered. So we are going to make our comments on each session. We started yesterday morning with 2 teams. Yesterday afternoon, we had 2 further teams. This morning, we had 1 team. And this afternoon, the 2 teams that are at the bar table. So Justice Jamada will give his comments on the first session yesterday morning. Justice Barrow will give his comments on the second session yesterday afternoon. Justice Jamada will return and give his comments on the session this morning with the 1 team. And then I will give my comments on the last team. And then we'll have give you a little idea of what we think of the law and the various issues, okay? So, Justice Jamada.
Yes, thank you very much, Madam President. So our first session was the moot between the Department of Law of the University of Guyana and the Department of Law of the Anton de Com University in Suriname. As we go through these sessions, we have selected winning team, best oralist, and best written submissions for each session. So I will start with that and then share just very, very brief comments because I think it's the end of the day and you really want to get to the big results, right? So out of session 1, the winning team was the University of Guyana. This is a court, but you can give them a round of applause. The best oralist was Miss Shanae Baksh of the University of Guyana. The best written submissions were from Anton de Com, University, Suriname. Before I share a few thoughts, I just want, for everyone's benefit, because now we're all here, just to recognize the participants in the moot. And from the University of Guyana, the senior advocate was Ms. Shanae Baksh, the junior advocate was Ms. Crystal Dookie, and the instructing attorney was Ms. Christine Richardson. The advisor was Mr. Chevy Devonish. For the University, Anton de Com University of Suriname, the senior advocate was Mr. Leroy Derby. The junior advocate was Ms. Leith Lindveld, and the instructing attorney was Ms. Ver, is it Baumgard? I hope I have that right. And the advisor was R.R. Bijgjokum. This first session, what struck us was that what was good about it is that both teams were very well prepared. We found them credible in their presentations. We also found that they were passionate and had a strong sense of interest in the materials. They demonstrated good levels of competence. We thought they understood their briefs and the arguments that they articulated. We did think, however, that what could have been improved was that they could have had a slightly better command of the facts. And we also thought that it would have helped them if they could have stated their cases positively from the outset. We think that in relation to session 1, that mooters could also be more aware of what the court is asking when questions are raised by the court and be responsive to those. But all in all, we thought that session 1 was a very good session. Of the actual participants, we do want to say that Ms. Baksh, are you present? Can you stand so everyone can recognize you? Thank you. That she was outstanding. Ms. Duki, can you stand up, please? Thank you. Ms. Duki weathered the interrogation admirably. Miss Lindfeld, articulate, very impressive. Mr. Darby, very well prepared and resolutely stuck to his brief. So congratulations to all of you. Madam Chair.
Yes, thank you very much, Justice Jamada. Justice Barrow on the second session.
The classical judicial formulation is I accept all that my brother has said in relation to the overall comments on our appreciation of the moots. It was heartening to reflect on the sense that I got as a judge with some experience that those who appeared before us conducted themselves as if though they were practicing attorneys for some little while. We were apprehensive at first about whether questioning the advocates in the way which we did over the 2 days, whether that was perhaps a bit too much since they are not practitioners, since they are not accustomed to this sort of treatment, was perhaps a bit unfair. I'm happy to say that while, of course, he took no part in our deliberations, we were heartened to get, as it were, an external view from the eminent former Professor Andrew Burgess, who is, as it were, the head of this mooting competition. So we came away satisfied that treating you all like lawyers was the correct thing to do and to have done. And I want to commend some of you for the way that you withstood it. My sister pointed out that one particular advocate seemed, in relation to the questioning, and it seems I'm the bad guy, in relation to the questioning from me, seemed to have come a bit close to crumbling, but then she caught herself and marched on solidly and to great or to considerable success. So my overall comment in relation to session 2 and in relation to all sessions is that you all have a lot to be proud of. I am so very happy to see this quality of performance, and I want to give you all a round of applause. Down to the specifics, I should make clear that the Moot rules contain a first schedule, assessment sheets, and these sheets set out the criteria which are contained, I think, in part 10 of the rules. So they deal with written submissions and oral submissions. They deal with things like content, strategy of written submissions, content, strategy, and advocacy in relation to oral submissions. So the ranking that we have done, the rating which we have done, in many instances was quite tight. And there are these 2 categories and 3 categories, but within those categories are a number of subheadings where we have to give marks for each subheading. So in instances, 1 point separated two teams. In another instance, I'm not speaking just of session 2, in another instance, I think half a point separated two teams, etc. So this is to see that there was not any vast disparity in the quality of the presentations, oral and written, and therefore, again, I commend the quality. As my brother has done, I think it is fitting to identify the participants in relation to session 2, which was between University of the West Indies Mona campus and University of the West Indies St. Augustine campus. For UWI Mona, the lead advocate was, sorry, the first advocate was Mr. Jamal Malcolm. The second advocate was Savion McFadden. Do I have that correct? Mm-hmm. Yeah. And the reservist was Ms. Kenish Johnson. Sorry?
They can stand.
Yes, would you three please stand? In relation to UWI St. Augustine, if you would stand, we have the first advocate, Solange Joseph. The second advocate was Maya Francois. And I think the reservist was Miss Anya Brunton. Do I have that correct? Would you please stand? Your colleagues are they are all there. There we go. Please sit down. A digression. The gender composition of the teams, I think, was quite notable. And I think after all the dominance of the male element in our society, it is not that the chickens have come home to roost, but it is that the tide has turned, and we now see who holds the balance of influence and power. So that I need not say anything more about the vast predominance of the female members on the teams. But ladies, congratulations to you. Gentlemen, congratulations to you for keeping up. The oral submissions, I think I will deal with that in the overall manner and just say that they were as good as one could reasonably and perhaps even ambitiously expect. And so were the written submissions. The best team, St. Augustine. The best oralist, Solange Joseph. Solange, please stand again. Congratulations. And the best written submissions, again, from St. Augustine. So, St. Augustine, you all swept it, which, as I said, is not an indication of any deficiency on the part of their competitor, because the marking, I can tell you, was in many instances, in fact, I think in almost all instances, a differential of 1 point. So there is no, as it were, lessening of the regard that Mona should enjoy. Two comments. In the course of the moots, I think we made references to the responsiveness of counsel to questions. Some of you did much better than others. I think you all did well. Nobody crumbled. Nobody failed to respond as best as they could to questions. A little caution. I started practice in the magistrates court up against police prosecutors. This was way back when. And there was in the magistrates court a tendency to be a bit nimble with the answers that you gave to the court. And I think that's putting it kindly. You would try, or people would try a thing. When you reach the level of the CCJ original jurisdiction, as well as appellate jurisdiction, when you reach the level, indeed, of the High Court, the advice is to be forthright with the court. If it puts you on the wrong foot, if it forces you to admit to something that you would really wish you didn't have to admit, I assure you, you will ultimately be better off for having admitted and recovering from it as best as you can. Do not, in place of admitting, come with some dodgy response. Do not put forward, as it were, an implicit excuse where it is not an excuse that is needed, but candid responses. So bear that in mind. And as well, it is important, and this has emerged, I'm not talking just about session 2, but this has emerged throughout. It is important for counsel to be very aware, very conscious of the fact pattern with which they are dealing, and as well to be clear on the concepts with which they are dealing. If you don't have your concepts correct, you will argue things which will lead you off in the wrong direction. It will lead you to a conclusion or to a path or to a determination of an issue which is not the issue you need to have determined, canvas, etc. You will be wasting your time and wasting the court's time. So getting your fact concepts correct, such as the Fair Trading Commission, for instance, that is not to be confused with any government regulatory body or, an NGO doing advocacy in favor of consumer rights and so on is not to be confused, let's say, with the Fair Trading Commission, which is a regulatory body, right? So that is the sort of thing which counsel need to pay attention to. This is a longish presentation, so I will cut my speech short. And again, just congratulate the participants in session 2. I quite enjoyed your performances. Thank you.
Yeah, session 3. The session 3 did not have 2 teams, just 1 team, the Heward Law School. And the mooters were Senior Counsel, Miss Ades Thomas. Yes. Is she here? Would you stand, please? Thank you. The Junior Counsel, Miss David E. Ramdas. And instructing attorney, Miss Carrie-Ann Manichan. The advisor was the principal of the law school, Principal Miriam Samaru. Yeah, you can have a seat, thank you. This is an interesting session because mooting, by definition, and one would think conceptually, should involve at least 2 teams. And so what do we do when we have 1 team? When you have 1 team, how do we assess them when other teams are competing against each other? It created a little bit of a challenge, and the way we resolved it, which may not have been ideal, was for the judges to be maybe a little more robust in our questioning. And the reason for that was to see how you would respond, because the assessment matrix had categories for your capacity to think on your feet, to be able to rebut. And if you were just speaking and there was no one that you were in competition with, then how do we assess that? So we played a dual role. In any event, judges these days are no longer passive umpires looking at ping pong and looking at the ball go left and right. In this era of the new CPR, judges are proactive and get maybe a little bit too much into the arena, but they get very involved in matters. So maybe it's good practice for you. Uncontested, yes. And so the winning team was, guess who? Hewwood Law School. We did have to choose of two, a winning oralist, the best oralist, and that was Miss Devidi Ramdas. Yes, please stand. It remains standing so that I can interrogate you publicly. But Ms. Ramdas was subjected to rather severe interrogation for those who were not here. And you were excellent on your feet. You were quick thinking. You were responsive, resilient, recovered well under extreme pressure. Don't think we didn't observe everything. We saw the little handshake and the little glossing over of you know what, we know what. But you stood steady under fire. And obviously you have prevailed. So congratulations to you. Of this team, I just want to add one comment, and that is, I thought they did something which no other team, well, they did something which no other team did, which I thought was excellent. Obviously, the brief involved a consideration of Articles 32, 82 to 84, and 91. And of course, you had to talk about the locus standi to come for special leave, Article 222. But what Hewwood Law School did, and their expression was that Article 82 is pivotal to the entire argument. And they started their presentation with Article 82. Now, all the other teams started with Article 32 and ended up having to say that Article 32 stands or falls on whether they can succeed in part on Article 82. But Hewwood chose what was, in their opinion and in ours, the pivotal point, put it forward as their first point, made it their strongest point, which in fact, on the facts, it probably is. And so as an advocate to the court, you put your best point forward, you make it. Once they could establish that there was a breach, at least it's arguable it is a breach, whether or not you qualify for the right of establishment or Article 91, which maybe were more iffy, you get leave. So they win their application to start. And then as they go along, they struggle along maybe with Article 32 and 91. I bring this to your attention because your brief set out in sequence, Article 32, 82 to 84, and 91, which is a sort of a chronological thing. That doesn't mean you have to be wedded to that. That was following somebody else's lead. If I had the time, I'll tell you about a little poem about a car 400 years ago that got a little intoxicated and walked home and walked a crooked path. And everybody for 400 years followed that crooked path. So you don't have to follow the path that has been set for you. You need to look at your circumstance and decide for yourself what is your best strategy. I'm not saying this is necessarily the best strategy or the only strategy. I just highlight it because they were unique in using it, and I thought it was very effective because at the end of their submission on Article 82, certainly the court felt, yes, it is arguable. And you remember, you don't have all the hurdles with Article 32 to get locus, right? You just have to be what? You just have to be a person. And they were registered in Trinidad. And Trinidad Cement says, if you're registered in Trinidad and you're a person in Trinidad, you can sue Trinidad. So they're in the door. Yep, Jamaica wanted costs. well, they would have gotten leave. So I just want to commend you for that, what I think is strategic creativity and what I thought was excellent advocacy. Thank you, Madam Chair.
Thank you so much, Justice Chairman. Our last session was an exciting and hard-fought session, and it involved two teams, Eugene DePooch, Law School, with the advisor, Ms. Pauline Seymour, and if you all are here, you can stand. The first advocate was Ms. Sasha Duncan. The second advocate, Ms. Chastity Butler, and the reserve, Ms. Tracy Ann Martell. You may sit. And on the other side was the Norman Manley Law School with their advisor, Ms. Tanisha Brown. And if you are here, you may stand. First advocate, Mr. Darian Street. Second advocate, Ms. Annaloy Lee. And the reserve, Ms. Audrine Cameron. You miss it. What two well-prepared teams. Teams that understood their briefs, understood what was at stake, and quite frankly, the only two teams, and in particular Eugene DePooch. It was a joy to read your opening statement, whether leave should be granted and whether there was locus standi. That was the key to this moot. And we were so very pleased that you demonstrated that high level of competence. And of course, you were not outdone by Norman Manley because you too started your written submissions on that point. We say, as we gathered together in our common room as judges and looked at this, I said to my colleagues, I am very happy because the profession is in very good hands. So I would really like to give you all a big round of applause. When it came to content, analysis, insight, there was a particular member of the mooting team that she just had to be told what it was, what was the question, and she took off. She went into case, this was that, and that is how we could compare. And she assisted us to a great extent. But generally, all the advocates before us did a fine job. We were very happy. Strategy, again, very good. Eugene DePooch paid attention to the objectives of the revised treaty. What is this really about? Why are we here? Why do we have a revised treaty? Why do we have a CCJ? And again, as to advocacy, all skillful advocates, some better than others, some more nervous than others, and that is to be expected. Don't worry about it. Your nerves will save you all your life. It will help you to perform at your best, despite how you think. But once you love advocacy, once you get into it, you will enjoy it more and more. You'll become more and more confident. And there was someone today, and I thought you would make a brilliant criminal attorney. I don't recall who that is now. But again, not a criminal attorney, a criminal law attorney. So congratulations on the level of advocacy that we saw. We wanted in particular to mention Ms. Chastity Butler. And I want to say this. Ms. Butler went, thank you, Ms. Butler went toe-to-toe with Justice Barrow. And she survived. And Justice
If I could intervene, Madam Chairman, we said that you went 10 rounds toe-to-toe, and we're not sure who came out the winner or the loser.
So as I congratulate you all, as we have heard all that you brought to the table, all that you addressed us on, on both sides. Sound arguments, persons who obviously knew what they were talking about. And that is what impressed us. Difficult questions from sometimes very difficult areas of law, and still you held your own, and we really are very happy about that. So we want to say for this session, the best oralist was Miss Chastity Butler. The best written submissions came from the Eugene Depute Law School for this session, okay? And the winner of this session was the Eugene Depute Law. So having gone through the comments, allow me to make a few remarks before I get into what we want to speak very briefly about what could be a possible outcome in this case. And we've already asked and acknowledged the excellence of the work that we have had these last 2 days. Thank you again. And I want to say that we all learned a lot. And I say we because I include the judges. You always bring fresh perspectives, and you look at issues in ways that we may not have thought about, may not have seen before, and we appreciate that. We were particularly grateful to the law schools, the academic institutions, your advisors, the persons who worked so very hard with you. Thank you, especially for those of you who have flown into Trinidad and Tobago with your teams. Thank you very much. We acknowledge the hard work that you have put in. And on behalf of Justices Barrow and Jambada, I wish to say again, well done. And as I believe it has been said the last few years, we don't propose to give a judgment as such, but we will give our thoughts and a few remarks on the issues of law. But before that, allow me to make just 2 short preliminary remarks. At our 2004 Moot, we decided that we would ask the teams to pay more attention to their written submissions. And I believe you all know that that is the world that you're going into. A lot of the work will be done beforehand and with your written submissions. As you're aware, this is the first year that we'll be awarding the Justice Jacob Witt Prize for the best written submissions. Last year, in his closing remarks, Justice Witt opened with these words: "Brevity is the soul of wit." Justice Witt disliked long and drawn-out written or oral submissions. He hated long and drawn-out judgments as well. Brevity was indeed his hallmark. We wish to place on record our deep appreciation for Justice Witt's dedication, not only to the CCJ, but to the CCJ International Law Moot over many years. This was one of his favorite annual events. He will be missed. May he rest in peace, and may his memory be a blessing. We also thought it important to highlight something. Let me see what this message is. Thank you. Yes, we thought it useful to highlight that what we did not see in many written submissions was an opening statement that would capture what was the key to the case. And we thought if you had to do such an opening statement, perhaps tonight or on the weekend when you have nothing to do, you could sit and think about this. TT Distributors Limited, a company incorporated under the laws of Trinbago, has applied to the court for special leave under Article 222 of the revised Treaty of Chagaramas to bring a claim against the state of Trinbago for breaches of Article 32, 82 to 84, and 91 of the revised treaty. Trinbago, in response, argues, among other things, that the court does not have jurisdiction and should refuse leave. the following issues arise. Would that not have focused your mind so that all we got about give us a declaration, give us a this, give us a that would not have played a part at all. So what were the main issues before the court? The first issue really concerned jurisdiction and locus standi. Several teams appearing for Trinbago argue that TT Distributors was not a national under 32.5 and therefore had no locus standi under Article 222. Article 222, as we all spoke about today especially, prescribes the conditions that must be satisfied before private entities are permitted to bring proceedings before this court. It is interesting to note that Article 222 does not require that private entities who desire to appear as parties be nationals, but persons, natural or juridical, of a contracting party. The court in TCL confirmed that. It pointed out the distinction between locus standi under 222 and nationality under 32.5. And in that case, as Justice Jamada, I think, well pointed out today, TCL had applied for special leave alleging a breach of Article 82 when Guyana suspended the CET on cement imported from third states. This court made the point that the provisions of Article 222 are intended to be available to persons of a contracting state, whether community nationals within the meaning of 32.5 or otherwise. This court in the TCL noted that Chapter 3 of the revised treaty concerns itself with issues critical for the success of an integration regime, such as the right of establishment under Article 32. The court pointed out that these fundamental core rights under Chapter 3 are not available to non-community nationals merely doing business in the community. So we heard over the days some well-crafted arguments on the issue of nationality under both domestic and international law, whether the requirements of Article 32.5 have been satisfied. But the questions we thought that there could have been a focus on was, one, whether TT Distributors is a community national or a national of a member state qualifying under Article 32.5. And even if it is, does the right of establishment under Article 32 inure for its benefit when it is not a national of another member state? And when you look at Article 32, and I don't have to read it, it speaks about the right of establishment of nationals of other member states. So having heard the several submissions, we are not quite persuaded that TT Distributors, not being a national of another member state, has made out an arguable case under 222 for the breach of the right of establishment under Article 32. And we were so very pleased that Norman Manley argued this point, and we saw it early in your written submissions. Well done. But of course, as Justice Jamada pointed out on more than one occasion over the last 2 days, the court can refuse leave on a ground and yet grant leave on other grounds. So you may also ask, as Norman Manley also did in their written submissions, whether Dominica Soaps Limited, who owned 55% of the shares of TT Distributors, could maintain a claim under Article 32. But that is for another moot, Justice Davis. The second issue was a misclassification, and I had to go back to my notes to make sure I did not say reclassification. The misclassification and the good faith point, because those were the key to Article 82. And there's no dispute that the Controller of Customs misclassified the soap noodles imported by Trinbago Soaps from Indonesia. and the tariff heading that was used was the incorrect heading. Of course, the question that was asked is, was this intentional? We heard really interesting submissions on good faith, whether it was, a genuine mistake. We were very, very pleased with those submissions. And there was reference by many of you to the DCP successors case, which was a fairly recent judgment of the court. So this pleased us. And the court reiterated in DCP that the CET is an important device that is utilized to achieve the objectives of the revised treaty. The court also noted in DCP that paragraph 18 of Schedule 3 stipulates that member states shall apply the rate of duty set by COTED on soap noodles, and that rate is 40. So that no matter how distressed a state is by the actions of the Secretary General or of COTED, there is no unilateral waiving or misclassification, or there is not anything that justifies, let's put it that way, a breach of Article 82 or 83. The court went on to say in DCP that Schedule 2 identifies a single circumstance in which the CET may be suspended on oils and fats and their substitutes, and that is where there is an insufficient supply. And that was something that we had hoped we would have seen more, because it featured so large in the DCP successors case that we really did think that you would have put a little more into it. In fact, I think just one or two teams even referred to Schedule 3, because Schedule 3 deals with oils and fats and other substitutes, and soap noodles fall within that. So when we do look at a case, let's not just look at one small aspect. Look at the whole case, read the whole case, and see how this could fit in. Of course, as I mentioned, we had thought-provoking arguments about the provisions of Article 83 and 84. We were told in the brief, and we tried to get some assistance on that part, that the Secretary General under Article 84 applied to the Trinbago applied to the Secretary General under Article 84 for a safeguard certificate to allow for the suspension of the 40% CT on non-community origin soap noodles. Justice Anderson, we'll speak more on that, because I am not sure that when one gets a safeguard certificate under Article 84, that with it comes a suspension under Article 83, because Article 84 is about goods of community origin. So it allowed, for example, if it had been obtained, it would have allowed Trinbago soaps to treat as goods of community origin their soaps, even though they had imported the soap noodles from Indonesia. Whether it would also have allowed them and authorized them to suspend the CET of 40 and charge a different, I just see, I'm not sure, I can't see, but given it some more thought, I thought that if you had one, you might need the other. So you might do both applications, one to COTED and one to the Secretary General. But that would be good for your advisors and your teachers and so on. And Justice Anderson, in his own capacity as, I imagine, a teacher of this area of law, to explore some more. Thank you. So we wanted to say as well that in DCP successors, we saw that the defendant state, the state of Jamaica, went further. Because what they did is that they originally classified the soap products as being goods of community origin, although the requirements of Article 84 had not been fulfilled. But I don't believe this is the case here. At least we have not been told that the Controller of Customs did any such, issued any such certificate. So that although we had hoped again that there would have been more, because I believe the fact pattern called, it teased out something, because it said that the goods were being sold both in Trinbago and Jamaica. So it meant that it had to go cross-border, it had to go to Jamaica. So was it going to Jamaica as a good of community origin? So that, I think, is an interesting question, and we could think about it. And finally, the defense of good faith. We have in several occasions, and I believe in DCP as well, remarked on the importance of the doctrine of good faith. In international law, it undergirds, I believe is the word we used, much of international law in general and treaty law in particular. We said that it is relevant to the process of treaty interpretation in accordance with Article 31 of the Vienna Convention, the law of treaties. And of course, you have very, very nicely put forward to us whether the facts and the evidence of the actions of Trinbago support its submission that Trinbago acted in good faith. We thought that you could have teased out some of the facts. We were, among us as judges, speaking about the really good senior counsel that we know, for example, in Trinidad and Tobago. And they're the ones that pick up the facts and they put it into the law. And I even said to them that there was a particular counsel that I knew. She used to be state counsel. And when she gave you submissions as a judge, you could take those submissions and write your judgment. She was so thorough and yet so simple. So we want to say when you have that sort of case, emphasize the facts, because in a lot of cases, the facts will allow you to win. So we thought, though, that looking at these arguments, it may very well be that TT distributors would have made out an arguable case for leave, for special leave to be granted on the breaches under Articles 82 to 84. And not to take up much time, because you really don't want to hear from me this afternoon, the third issue about the Article 91. To us, the most interesting, the most fascinating of all, we wish a case would come to us under Article 91. So many aspects to it. Of course, there was no CCJ law on it, so you were expected to look at the cases of other places, other jurisdictions. Many of you went to the ECJ, some of you went to Professor Berry's excellent book. Some of you ignored it and just didn't think that that you could get anything more from it. But we were heartened to hear you argue about difficult areas, measures equivalent to a quantitative restriction. What is that? How does that fall to be analyzed? You even you found some creative ways how to show us that a breach of Article 82 could fall here and why. We were really very, very impressed by all that you did. The reference from the Apple and Pear case, the Dassonville case, I believe there was the Irish case as well. Several of you did the hard work required to show us what you could do, even in a situation where the law was not just readily placed before you. So well done. Compelling arguments. Is Trinbago responsible under Article 91 for the acts of TPSO, a private sector body? That was interesting. But it was a campaign by TSPPO and the imposition of the wrong tariff. Would that amount to measures equivalent to a quantitative restriction? And another key issue was whether could TT distributors be a Trinbago manufacturer really argue that Trinbago had reached 91, or whether that's a matter for national court. That is another question. And of course, we heard some stimulating, novel arguments about Article 177, the prohibition of anti-competitive business conduct. We note that TT distributors did not rely on that in their application for special leave, but it was argued. Mr. Skeet, is it? You wanted to strike them out. And you also wanted a stay. In other words, they wouldn't get their case done at all or ever heard. But we thank you for taking that initiative, because that showed that you were thinking, that you were bringing something very special to the table, and we appreciate that. So it may be, and I think Justice Jamada and Justice Barrow will agree, that we think the Article 91 point is it's not just interesting, but it's important. I think Dr. Berry made that point, that states could use sophisticated means to discriminate against CARICOM origin goods in favor of their own domestic goods. So this Article 91 is important. It's something for us to keep our eye on. And in that case, I believe the court may very well say that an arguable case has been made out and that leave should be granted. But again, Madam Registrar, this is for another thing. And I thank you all.
We will rise for the relocation of the members of the bench. Comments may go a minute. Ladies and gentlemen, good afternoon and a very warm welcome to the closing ceremony of this, our Crown Jewel event for the 14th annual CCJ International Law Moot competition. Allow for my early recognition, in his absence, of our host, Mr. Justice Adrian Saunders, President of this venerable institution, Mr. Justice Anderson, Judge of the CCJ, deputizing for President, Mr. Justice Andrew Burgess, Chairman of the CCJ International Law Moot Steering Committee, Madam Justice Rajnath, Mr. Justice Barrow, and Mr. Justice Jamadar, 2024 Moot judges, senior management of the CCJ, principals and deans of participating institutions, managers, supervisors, and staff of the Caribbean Court of Justice and the RGLSC, Moot team advisors, our 2024 Mooters, other specially invited guests, members of the media, and our online audience, distinguished ladies and gentlemen. With brilliance, eloquence, and elegance, together with some degree of zeal and camaraderie, students from 7 regional tertiary institutions showcase their in-depth knowledge and understanding of the principles enshrined in the revised Treaty of Chaguaramas over the last 2 days. Theirs was no easy task, for they had to withstand the 40 stellar years of sound private practice experience of Mr. Justice Barrow, the keen eye ability of Ms. Statutory Interpretation herself, Madam Justice Rajnath, and the evidential burden guru in Mr. Justice Jamadar. Ladies and gentlemen, for all that and more, I ask that you join me in a hearty round of applause as we salute their tenacity and strength for a job beautifully done. Mooters, your excitement for the results remain palpable, but we must speechify and hear from 2 of the main players in this activity. In February 2019, a seamless and most fitting transition of chairmanship of the CCJ International Law Moot Committee in the person of Mr. Justice Andrew Burgess was made, following the retirement of Mr. Justice Hayton. Over the past months, it was my signal honor to be part of the Moot Steering Committee chaired by our first speaker. His oversight, his guidance, and his vision for the competition, together with his charm, sophistry, and quiet diplomacy, were sincerely appreciated by all members as he steered the SSS Moot 2024 ship safely into harbor. It gives me the greatest delight and pleasure to welcome to the lectern to deliver opening remarks, Mr. Justice Andrew Burgess, Chair of the CCJ International Law Moot Committee. Justice Burgess.
I must confess that this is the first time that I've been introduced by a female ceremony, mistress of ceremony, master of ceremony. I did the research and she's a mistress of ceremony. Thank you very much, mistress of ceremony. And permit me to adopt all the protocols that have been so expertly established by you, Mr. Susan. This evening, I address you as chairman of the CCJ Law Moot Committee. In this regard, it is for me an honor and an undiluted pleasure to extend warmest welcome to all of you to this closing ceremony of the 14th annual CCJ Law Moot competition. This is our second in-person moot since 2019, and I must confess that I was totally impressed by the enthusiasm and dedication demonstrated by the moot teams over the last 2 days, and the extremely high caliber of your arguments presented before the judges. Our crafty judges raised some tricky questions with you during your oral presentations. I must confess that you dealt with these questions with admirable adroitness. When you knew the answers, Your responses were absolutely brilliant. When you did not know the answers, you deftly sidestepped the questions. The parrying between the wily bench and you, the young mooters, was thoroughly enjoyed by us, the audience. May I bestow my sincerest congratulations to all of this year's mooters. You did yourselves and your institution proud. Since 2008, this Moot competition has been a marquee event in the calendar of regional law schools and law faculties. We at the CCJ are aware of the importance of the competition in contributing a Caribbean perspective to you, our up-and-coming lawyers. Accordingly, the objective of the Moot has always been to provide the opportunity to educate and foster greater interest on the workings of the revised Treaty of Chaguaramas and the development of its jurisprudence in the CCJ's original jurisdiction. In hosting this Moot, we wish to demonstrate our investment in you, the future attorneys of the region. The issues raised in this Moot competition are issues which have arisen or which may arise in one fashion or another during your career. And who knows, you may appear before the CCJ in the future litigating these or other issues. As a former teacher in the UB Faculty of Law for over 35 years, I started when I was pretty young. I have witnessed the strengths that can be developed and the weaknesses that are discovered by students through a mooting competition. The entire experience, from preparation of arguments to standing before the court, making these arguments, improves a participant's overall understanding and knowledge of the area of law. Students gain invaluable training in written and oral advocacy, coupled with the honing of legal research, analytical, and reasoning skills. This knowledge and these skills are and will be extremely valuable and eventually considered as advantageous by your future employers or by yourselves should you choose to practice on your own. Simply put, this Moot experience will no doubt be remembered by you as a defining landmark in your development as attorneys and jurists. On another note, it gives me great pleasure to announce that this year, as Madam Justice Rajnath Lee has pointed out, we have introduced a new prize, the Justice Jacob Witt Best Written Submission Prize, in honor of our dearly departed friend and colleague on the bench, the Honorable Mr. Justice Jacob Witt. This prize will be presented to the mooting team, which displayed the greatest analytical and communication skills in their written submission. Justice Witt, as Madam Justice Rajnath Lee pointed out earlier, was a perennial judge of this Moot competition. He challenged mooters with some tricky interventions, but charmed them in equal measure with his wit, no pun intended. His passing is without doubt a monumental loss for this Moot competition. The CCJ in general, the courts in Curacao and St. Martin, and to the entire Caribbean region. He was a truly eminent jurist who made an enormous contribution to the development of Caribbean jurisprudence. Before I close, I would like to personally thank my sister and brothers on the Moot bench. Madam Justice Rajnish Lee, President and Presiding Judge, and Messrs. Justice Barrow and Jamadar for dedicating their time and energy to this year's competition. We truly appreciate their skillful use of the Socratic method in making the moot extremely interesting. Could we raise a round of applause again for... As chair of the Law Moot Committee, I also wish to extend my deep appreciation to the members of the Moot Steering Committee, the subcommittees, and all those who tirelessly dedicated their time and energy to the staging of this competition. They too deserve a round of applause. A special thank you must also go to each and every one of the moot teams, the students and the advisors for participating in the moot competition and contributing to its resounding success. For those of you who travel to participate, I hope you have enjoyed your short stay here in Trinidad. And I think that these mooters also deserve a round of applause. Finally, I must extend my sincerest, but it has to be anticipatory congratulations to this year's champion team, whichever it may be, on your victory over the other teams to win the coveted CCJ Shield. I thank you.
Thank you, Justice Burgess. Each year, the CCJ Law Moot competition receives the blessing of the President of the Court. He fully comprehends the benefits of a competition of this nature to inter alia swing the pendulum favorably towards the Caribbean's young generation of jurists. It is therefore fitting for him to deliver an address to you. President Saunders is without his charming and reassuring voice. As such, Mr. Justice Anderson, our next senior judge, will address you on President's behalf. Ladies and gentlemen, Mr. Justice Anderson.
Well, you're warned that my voice is not quite as charming as the President. With all protocols having been formally established at the start by the Master of Ceremonies, Mrs. Giselle Thomas Roberts, please permit me to adopt them and to extend a very warm welcome to all of you, distinguished colleagues in the law. I must again enter the regret for the absence of our esteemed President, Honorable Mr. Justice Adrian Saunders. He's not here with us because he has still not recovered the use of his voice, which is a big disappointment to all of us, especially to certain members of staff who, rumor has it, we're going to approach the President today to ask for a huge increase in their salaries. They were confident of success since they knew that the President could not say no. We have come to the end of an engaging 2 days of competition. Yesterday, we reflected briefly on the nexus between the revised Treaty of Chaguaramas, the RTC, establishing the CARICOM community, including the CARICOM Single Market and Economy, the CSME, and the annual Caribbean Court of Justice International Law Moot. In these annual competitions, we try to ensure that there is enhanced awareness about the RTC, the CSME, and the mechanisms designed to promote regional cooperation. The participants in this competition are the future attorneys and jurists of this region. And we hope that appearing before the court, engaging our judges, becoming acquainted with our jurisprudence and court processes will spark a fire to know more about the court, the revised treaty, and the rights and obligations thereunder. I had the opportunity to meet and converse with most of the mooters and their advisors, albeit in a more culinary context. We observed the embargo on discussing issues related to the moot, but I was struck by the willingness to engage in regional legal issues. I was also able to attend the last moot and was suitably impressed by the skill with which the arguments were presented and the adroitness with which salvos from the bench were parried. Only one team will walk away with the challenge shield, but you should be each proud of yourselves for the considerable time and effort poured into this experience. Your dedication to refining your written and advocacy skills, grappling with the complex issues presented, and stoutly defending your interests before the region's highest court is truly commendable. So as we draw the curtain on the 14th Annual Caribbean Court of Justice International Law Moot, and on behalf of the President and fellow judges of the court, I thank and congratulate you all for your dedication and eagerness to participate in this exercise. We applaud each and every one of you for your outstanding efforts. Our appreciation also goes out to the principals, deans, and advisors from the Department of Law of the University of Guyana, Faculty of Law of the Anton de Kom University of Suriname, from the Faculties of Law of the University of the West Indies, the St. Augustine Campus, Trinidad, Mona Campus, Jamaica, Hugh Wooding Law School, Trinidad, Eugene Dupuche Law School in the Bahamas, and the Norman Manley Law School in Jamaica. Lastly, I must congratulate my brother, Justice Burgess, and his team. This year's event has turned out once again to be an outstanding success. Justice Burgess's unwavering commitment and dedication, and that of the entire team behind the scenes, must be acknowledged and commended. Indeed, the entire management and staff of the court and the Regional Judicial and Legal Services Commission should be lauded for once again supporting and collaborating in the organization of the moot to ensure that it went off without a hitch. Special commendation must, of course, go to our newly minted moot bench. The Honorable Madam Justice Rajnath Lee, who did a fabulous job in chairing the moot. The Honorable Mr. Justice Dennis Barrow, whose piercing questions were delivered in impeccable baritone voices. And the Honorable Mr. Justice Peter Jamadar, whose incisive questions were delivered with his characteristic smooth and silky way of doing things. We once again remember, as we always must, the Honorable Mr. Justice Jacob Witt. He was truly missed over the past 2 days, and we pay tribute to him. His indelible contributions to this esteemed competition, to the field of legal education, and to the regional jurisprudence will forever be remembered. Special commendations to the team winning the Justice Jacob Witt Prize for the best written submissions. I thank all of you, our special invited guests, some of whom have just arrived, and our online audience for your support in this year's Moot competition. To all the Mooters, I extend my best wishes to you for a successful and fulfilling journey ahead. May you carry the lessons learned and the connections made during this Moot with you as you embark on your respective legal careers. And it is my hope that you continue to remain interested in the work of the court. Our website and social media platforms are updated almost daily with news of our judgments, the work of the court, and our affiliate institutions. We occasionally advise, or advertise, I should say, for Judicial Council to provide research for our judges. We encourage you to keep abreast of these developments and to urge your colleagues to do likewise. Again, on behalf of President Saunders, I bid farewell to you all. For those of you based in Trinidad, welcome back to your normal activities after the Moot, whether on the avenue or elsewhere. For those of you who must travel back to your home countries, I wish you an enjoyable stay in Trinidad and safe travels back home. And now the work is done. Time has come. It's time to raise the roof and have some fun. Best wishes for a safe, happy, and celebratory afternoon. Good afternoon.
Thank you, Mr. Justice Anderson. And may I recognize the presence of Dr. Anthony Gafour. He's the chairman of the Tax Appeal Board. Welcome, sir. 3 years ago, the Social Media Spirit Prize was introduced in recognition of the immense power of social media as a tool for good. The overall aim of this prize was to allow supporters and well-wishers from the participant circles and the community to send support, well wishes, and encouragement to their teams. By using a specific hashtag, supporters were able to send messages across social media platforms. These messages were then calculated using the hashtag as a guide. Ladies and gentlemen, after careful calculation, the institution which received the highest number of messages was the Norman Manley Law School. And they won this prize by 1 point over the University of Guyana. The winning team will receive gift cards from Amazon valued at $50 US. I now invite retired Colonel Donley Wyke, Chief Security and Logistics Officer, to present the prizes to the students. If Colonel Wyke is not with us, I would ask Mr. Ramnanan, our Senior Manager, Corporate Administration, to so do. Thank you, Mr. Ramnanan. So I'm calling the names, Darien Street, Analoy Lee, and Audrine Cameron. Thank you, Mr. Ramadan. Long before the iconic David Rudder and young Olatunji Yewood coined in their own inimitable style the term engine room, the CCJ's registry was ahead of the pack. The court's registry, fondly called the engine room, plays a critical role in managing all matters before us from filing to disposition. This role provides a beacon of support to the president and judges, as we are the advance party before matters reach the bench. The law moot competition is no different. Over the past month and a half, and culminated in the last 2 days, my team and I saw the dedication, commitment, professionalism, and staying power of a group of 11 students from the Faculty of Law, University of the West Indies, St. Augustine. It is therefore fitting that we invite each of them to receive a certificate of appreciation for their involvement and contribution to the success and seamless flow of this year's competition. Ms. Heather Dyer Thompson, Registry Supervisor, whose astute guidance was pivotal throughout the orientation and training of the students, and Mr. Shivanan Ramnanan, Senior Manager, Corporate Administration, will present the certificates. Ms. Racheline Bettel, Moot Registrar. Mr. Justin Ramdas, Moot Registrar. Ms. Cheyenne Roberts, Moot Judicial Council. Ms. Naomi Cabrales, Moot Judicial Council. Mr. Shirvan Prasad Maharaj, Moot Judicial Council. Ms. Shakira Bonnet, Moot Support Officer. Ms. Yelena Cortez, Moot Court Support Officer. Ms. Faith Webb, Moot Court Multimedia Officer. Ms. Anupriya Pasadi, Moot Court Multimedia Officer. Ms. Claire Hudson, Moot Court Marshal Usher. And finally, Ms. Kavya Lalu, Moot Court Martial Usher. Thank you very much, Ms. Daya Thompson and Mr. Ramnanan. This year's fierce competition featured 7 academic institutions and law schools, all vying for the grand prize. The sad reality is that there can only be one winner. To the other institutions, be encouraged in knowing that you showed up for yourselves and your schools and appeared before the apex court. Ladies and gentlemen, the recipients of the bronze medals placed in 3rd in this year's competition, and I now invite the Honorable Mr. Justice Peter Jamadar to present the prizes. University of Guyana. Ms. Sinead Bash, Ms. Crystal Duki, and Ms. Christine Richardson. Bekum University of Suriname. And today I miss Justice Witt because some of these names may be difficult to pronounce, but I have Mr. Justice Barrow. So it's Leroy Darby. Edith Lindveld. Olivier Baumgart. Could we just ask the team from the University of Guyana to come back for a group shot, please? Thank you so very much. Yes, yes, please. Thank you. And in the meantime, could the students from the University of the West Indies, Mona campus, get ready to receive their bronze awards? Yes, I will. Yes. Thank you. The University of the West Indies, Mona campus, Savion McFadden, Jamal Malcolm, and Kanish Johnson. Please don't go, you have to do the group shot. Thank you. The Norman Manley Law School. Darian Street, Annaloy Lee, and Andreen Cameron. and Hugh Wooding Law School, Trinidad and Tobago. So, Andy Thomas, David E. Ramdas, and Kerry-Ann Manichan. Thank you, Mr. Justice Yamada. And we are getting to where the air is rare. Silver medals are awarded to the team which placed second overall. I invite Mr. Justice Dennis Barrow to come forward to present the prizes. And our second place winner, the University of the West Indies, St. Augustine Camp. Blanche Joseph, Anya Bronson, and Maya Francois. Thank you, Mr. Justice Barrow. The Henry Ford Best Oralist Prize was introduced last year to recognize the mooter whom the judges believe best embodied the essence of his or her role. This person is recognized for his or her oratory and advocacy skills during the competition. It is made possible through the donation from a kind benefactor. Last year's winner went on to become one of the 2023 valedictorians at the UE Cave Hill campus. Who knows where and what future achievements are in store for this year's winner? I know for sure that we will continue to hear from him or her. I therefore am pleased to announce that the winner of the 2024 overall Sir Henry Ford Best Oralist Prize of a US $250 Amazon gift card is Miss Chastity Butler. Maureen Watt-Buckley, our 2024 Moot panel chair, will present this award. you, Madam Justice Rajanapi. On 16th February this year, the CCJ and the region and the world lost a most eminent legal luminary and distinguished jurist, and for me, an amazing mentor and friend. The late Mr. Jacob Justice Witt was a member of the inaugural bench of the CCJ and dedicated 18 years of service to the court and building of Caribbean jurisprudence. For the next 5 years, another kind benefactor will donate a prize in his honor. This year, the winner of the inaugural Justice Jacob Witt Best Written Submission Prize of US $150 gift card, Amazon gift card, is Eugene DePooch. Chastity Duncan, Chastity Butler, and Tracy Ann Martell. Thank you, Madam Justice Rajanapi. The Best Academic Institution Prize is awarded to the academic institution, that is the non-law school, which in the judge's opinion has performed exceptionally well and distinguished itself from the others. In 2024, the winner of this prize is the University of the West Indies, St. Augustine Faculty of Law. I invite Mr. Justice Andrew Baker, Chair of the International Law Moot Committee, to present this prize. Thank you, Mr. Justice Burgess. And as Justice Anderson said to me recently, it is the appointed hour. I am happy to announce that the Board Award, the Moot Challenge Shield 2024, will be awarded to the Eugene DePooch. The team comprise Sashay Duncan, Chastity Butler, and Tracy Ann Martell. They received gold medals, Amazon gift certificates valued at US $150 each for their outstanding performance today. I now invite Mr. Justice Winston Anderson to present these prizes. Justice Anderson. And they also received gifts on behalf of the court. And these books are donated by Mr. Justice Winston Anderson, legendary Caribbean legal practitioners. And we thank Ms. Pauline Seymour, the advisor, for preparing them. And the shield. Cheers. Yes, it's free now. Thank you, Justice Anderson, and could we applaud our gold winner for 2024, Eugene DePooch Law School. The CCJ's registrar and the Chief Marshal, Mrs. Gabrielle Figaro-Jones, will deliver some closing remarks. Registrar.
Thank you very much, Ms. Thomas Roberts, and what an excellent job you have been doing. With all protocols having been formally established by the previous speakers, I adopt these protocols and wish you a very warm good afternoon. It is an honor and a pleasure to bring these closing remarks on this significant occasion, the 14th Annual Caribbean Court of Justice International Law Moot Competition. The judges and staff of the CCJ take great pride in hosting this event. The Law Moot competition, as you have heard repeatedly over the last 2 days, is a hallmark on our court's calendar. This is because it provides an opportunity to cultivate a unique connection between our institution and the vibrant legal minds that represent the future of the region. You have also heard that it provides an unparalleled opportunity for students to increase their knowledge and understanding of the CCJ's technology, court processes, registry staff, the original jurisdiction rules, case law, and ultimately the revised Treaty of Chaguaramas. But I wish to share with you another aspect of this competition. The court allows some of the region's students a glimpse behind the scenes. We ensure that students do not have the opportunity to only experience the courtroom, but to also experience the Moot Registry. Our Moot Registry officials this year are the first-year law students of the University of the West Indies. They were taught about the procedural steps, St. Augustine. They were taught about the procedural steps and processes necessary from the filing to the disposition of cases. They gained insights into the electronic filing system and the case management practices. Among this year's participants, we may find future judges, other judicial officers, and judicial counsel, for whom knowledge of effective case flow management would prove beneficial, enabling them to efficiently manage their courts, whether from a judicial or administrative perspective. As part of the court's strategic plan, Strategic Issue 6 to be specific, the court recognized its responsibility to enhance regional justice system capacity and performance. It recognized that such enhancement goes far beyond the hearing and determination of cases. It includes fostering and inspiring the entire regional culture that supports the development of such jurisprudence. Therefore, deliberate attention is paid to solidifying professional and collegial relationships with regional institutions that contribute to the building of Caribbean jurisprudence. This is why you are so important. The court is so invested in this objective and by extension this event, it strives each year to make it better. The Honorable Mr. Justice Burgess, Chair of the Moot Steering Committee, guided the committee with grace, efficiency, and experience. He ensured that the committee, although hard at work since last year, was well-paced and on top of its deliverables. Justice Burgess, we thank you, sir. Expertly handled. We must say a heartfelt thank you also to the entire steering committee. This committee was divided into two subcommittees, which were led by Registry and the Public Education and Protocol Unit. We call it PEPU. First, a special thank you to our Deputy Registrar and Marshal, Mrs. Thomas Roberts, who led the Registry, who led the Registry Subcommittee, and upon whom the role of Moot Officer was thrust. This was after the departure of our dear former Moot officer, Mr. D.K. Noel, from the organization. Mr. Noel was certainly missed. However, I think he would be proud that he left the internal Moot planning mechanisms in place to ensure a smooth transition. Deputy Registrar, Registry Supervisor Ms. Heather Dyer Thompson, Ms. Jacqueline Swaby, Mr. Anil Ramsahai, and Mr. Aaron Alexander, you have done an outstanding job. Another special thank you is due to Ms. Denise Douglas, the Chief Public Education and Protocol Officer acting, who led the PEPU subcommittee. She was ably supported by Ms. Alana Tasha, Ms. Danielle McConney, all under the guidance of the Communications and Information Manager, Ms. Ria Mohammed Pollard. This team, I cannot forget Mr. Howard Marcel also. This team worked tirelessly, and we are profoundly grateful for your remarkable efforts. The steering committee, to which I have referred, comprised of other staff members from across the court. I need to acknowledge the library unit, the information systems department, the security and logistics unit, the facilities and asset management unit, and the finance and administration department. All of these departments must be commended today. These teams have performed impressively. Mr. Shivanan Ramnanan, Senior Manager of Corporate Administration, thank you always for your unwavering support. We must also thank our many liaisons who have provided support today and throughout the process. They ensured that our mooters and their advisors were oriented to the precincts of the court, to the schedule over the two-day period, and to the competition itself. Ms. Veronica Brooks, Ms. Wendy Mitchell, Mr. Anna Ramsahai, Ms. Candice Kayono, Ms. Helena Ali Victor, Ms. Crystal Charles, and Ms. Jacqueline Swaby. Thank you. We extend appreciation also to the persons who have joined us via our YouTube channel and to those who are present with us today. We are honored that you have taken the time from your busy schedules to support the advancement of Caribbean jurisprudence. Special recognition must be accorded to our sign language interpreters, Ms. Niobe Rodriguez and Ms. Johanna Reyes, who are interpreting this closing ceremony as we speak. On the 19th of March, the CCJ took a groundbreaking step and introduced sign language interpretation into our judgment delivery process. This is a part of our continuing efforts to enhance accessibility and inclusivity and aligns with the court's mission to provide accessible, fair, and efficient justice to the people and states of the Caribbean community. Stay tuned. As the Court's Committee for Improving Access to Justice for Persons with Disabilities, expertly led by the Honorable Madam Justice Rajnath Lee, is continuing to develop initiatives, policies, guidelines to ensure that we remain an accessible and inclusive court. To the esteemed panel of judges, Madam Justice Rajnath Lee, Mr. Justice Barrow, Mr. Justice Jamadar, thank you for sharing your invaluable time, knowledge, and experience. I know that the students will remember appearing before you and I know that the lessons learned will resonate with them for years to come. As we draw closer to the end of this year's Moot, there is a lurking sense of sadness. As we mentioned before, we lost our dear distinguished Mr. Justice Jacob Witt. I cannot think of a prize more fitting to be named in Justice Witt's honor. To the recipient of this prize, we urge you to hold it dear because it was awarded with profound significance to this court. To the President of the Court, the Honorable Mr. Justice Adrian Saunders, who regretfully could not be with us today. To the Honorable Mr. Justice Anderson, who graciously stepped into his stead. Thank you again for your continued support of this competition. Last but really could never be least, what is the Moot without its participants? We wish to extend our deepest appreciation to all of the institutions who continue to express interest in this competition and to the advisors who have worked tirelessly with their teams. And to you, Mooters, you have done yourselves and your institutions incredibly proud. I can assure that hearty congratulations are indeed due to you. May the spirit of fairness and intellectual curiosity be your constant companions in all aspects of your work and life. And to the winners of the 14th annual CCJ International Law Moot Competition, the Eugene Dupuche Law School, we extend our heartiest congratulations to you. And on this celebratory note, I warmly invite our specially invited guests to accompany our Moot participants in celebrating their accomplishments at a short reception upstairs. Our ushers stand ready to guide you. Thank you, ladies and gentlemen. Okay. I just received a note. There is someone very special who worked very hard that we must give recognition to, Mr. Suraj Sakal, our recently minted judicial counsel. Sir, thank you for all the work that you have done throughout this Moot. Is he here? We want you to see who he is. Could someone tell him, please? They said, come forward. Justice Rajnath Lee just said, we gave him more and more work, and the more work that we gave him, the more he did. Thank you so much, Suraj. Job well done. Oh. Thank you so much, Suraj. I received another note. Another liaison was Miss Candice Simmons. I failed to mention you. My apologies. Well done, Candice. All right. How many messages can I get? Another message. There's a request for all of the teams to gather so we can get photos before you proceed upstairs. So I invite you now to come forward, please. And thank you very much, everyone. Have a great afternoon.